Welcome to another episode of Hunter Simmons interviewed on the Jim Bratton podcast. Now, here are Hunter and Jim.
Today, we're again talking to Hunter Simmons Law Firm. I think we've got an interesting subject today, Hunter, that you've mentioned to me. How are you doing today?
I'm good, Jim. Happy Labor Day. We continue to have these on national holidays. So
you're right about that. So what are we going to do? We're going to have no more podcasts when you run out of national holidays?
I hope not.
This is an extension of something. We talked about this earlier, and you were really excited about this, but tell me about this last episode that you want to talk about today, and then we're gonna put that in basically parenthetically the home of the brave. Okay, so let's work through that.
So I'm a criminal defense lawyer, and I theorized in our first podcast that, at the end of Star Spangled Banner, it says land of the free and home of the brave. And I think that home of the brave kind of alludes to speaking specifically about the context of what I do, which is generally defending the Constitution for the citizen. Is these rights aren't just going to be given to you, right? Like, we have certain legalese in the legal world, like presumed innocent, and you have the right to be safe in your home, guaranteed by the Fourth Amendment. And that when a cop lies about a warrant and you ask him about it, your cases don't automatically get dismissed. So that brings us back to I'm gonna tell you about the home of the brave in this specific context that we were talking about earlier, Jim.
Okay.
So the long and short of it is my client was charged with 3 felonies back in February of this year.
Right.
And I was not his first lawyer. The court appointed him a lawyer. And what's unfortunate about that is that he had a blue warrant. And so what's a blue warrant?
What is a blue warrant?
Yeah, I apologize. I just start going on narratives and I forget that, I just want to get the points as quickly as possible. So
I don't want to sidetrack you too much, but give you a little quickie.
No, you're good. You're good. A blue warrant is what happens when a citizen is on parole and they're accused of committing what's called a new law violation. So charges have been filed against them and an indictment has been filed, right? So at that point, just for our specific context here, it becomes extremely difficult to get my client out of jail. He even if he's one of the rights we enjoy as unconvicted felons is the right to reasonable bail. But when he was already on parole, he loses that right if he gets picked up again.
That's interesting.
So when I got this case, I was hired. So remember I said in February, the court-appointed lawyer was appointed to represent him. My client got a little impatient, shall we say, because he could not get out of jail. And, unfortunately, even if the case is bullshit, you can't just go to the DA and be like, look, see, the case is bullshit, right? And they'll just dismiss it. That's not the way our justice system works. So
right.
What I did when I got subbed in on the case is I immediately reviewed the evidence. I immediately realized that there was a lot of problems with the evidence. Specifically, the 3 felonies that my client was charged with, one of them was aggravated assault with a deadly weapon. The victim in this case alleged to this officer that my guy pointed a gun at him, right? So you can be convicted in Texas of aggravated assault with a deadly weapon, even if you point a gun in. So you don't have to touch anybody. It sounds terrible, right? Aggravated assault with a deadly weapon. You must have done something very bad. But you could literally be found guilty of that with a fake gun in your hand, assuming that the victim perceives that they're in quote unquote imminent fear of immediate bodily harm. Something along those lines, right?
Yeah, yes, understood.
Okay, I said all that to say this. That was the inciting incident for what this police officer did to charge my guy with 2 more felonies. One being unlawfully carrying a weapon, which there was no causal connection between the gun that was allegedly being pointed at the victim, and the gun that was found after the police officer raided the house, right, with all his buddies. They found a pistol in my client's wife's purse. And as you can see on the body cams, this officer did not turn on his body cams for this home raid, which was another thing that led us to believe that he probably was implicitly admitting that what he was doing was wrong.
Right. Normally the body cam would go on, right?
Right. So in the event you have a lawyer that's not going to make the government give you your rights, right, then this guy could have gotten a felony conviction and stayed in jail for a long time. I think the offer going into trial was 10 years TDC on the retaliation charge. We declined to take that offer, and we picked a jury, and then we had what's called a suppression hearing. And so let's go back to the inciting incident, Jim, which was the aggravated assault that incited the 911 call from the victim. The officer interviews the victim. It's on his body cam. We get to see that. The unfortunate thing about that, I'll let the public believe or not believe the officer, the audio on the body cam wasn't working. And so that would have been a wonderful opportunity for us to get how much fear the complaining witness was in when they called the police, but we didn't get that. All we got was 47 minutes of muffled talking. And I said all that to say this. We have every citizen in this country enjoys the right of being safe and secure in their homes from government intrusion that's not based upon a warrant, a valid warrant, or probable cause. Okay, we don't have any objective, real-time testimony from the complaining witness to the officer because of that video. But what we did have was later, for whatever reason, he was calling, he being the officer. So he's investigating the aggravated assault now, and we're releasing the hounds, right, to go take my client in. They run a little search on his car. They figure out where he's living. And as he's waiting outside my client's home, he calls the DA. The district attorney's office in Harris County has what's called an intake division.
Right.
There's a DA basically on call 24/7 to determine whether or not probable cause exists to file charges against, in this case, my client. So the officer calls the DA, and the DA says, well, I need you to get me a statement from the victim that says he was in fear of imminent bodily harm or death. So herein lies the rub. We're all human beings, right? And we're all, if it walks like a duck and talks like a duck, it's probably a duck. So the duck in this case was my client. The officers invaded the home without a warrant. So in order for any evidence they find without a warrant, there has to be probable cause for that. And the warrant and the exception to the warrant requirement in this case was the officer claimed exigent circumstances. Okay, exigent circumstances is an exception to the warrant requirement, which basically it's basically the officer saying, yeah, we didn't have a warrant, but we had probable cause, and here's why. Exigent circumstances mean if the officers don't act, number one, if the officers don't act, someone's going to die. Okay? Someone is going to be harmed by the defendants. There's a wild man running around.
Right.
With a gun.
This is like in a standoff or something kind of thing. Is that typically where somebody's holding someone hostage? Is that the typical use of exigence in?
Sure, that's a good example. And with the hostage example, that's a very complicated and fragile situation. Like the negotiators don't want to barge in and everyone dies, right?
Right.
But actually, another example of that, Jim, is like, say someone's running around with a gun and they're shooting in the air, and there's been multiple reports of it. I think this happened in Detroit or Michigan earlier this year, but the cops got to go find this guy, right? And so they get into a description of him. They get where he is located from like public records, and then they can go in and try to find him without going to a magistrate first to get an arrest warrant. That takes some time.
Right.
Okay. Another example of an exigent circumstance is if the cop reasonably believes that if they don't act now, that evidence will be destroyed. For example, like flushing drugs down the toilet. Okay.
Yes.
If an officer hears that in like a hotel room, that could be a possibility for exigent circumstances to enter the hotel room. So destruction of evidence is another quote unquote exigent circumstance. In this case, though, it was aggravated assault with a deadly weapon, right? Which basically means that if the cop doesn't act now, people are going to die. Here's the rub. And this is why at the Simmons Law Firm, all my clients enjoy a $0 trial fee.
Right.
And all my clients have a lawyer that genuinely believes, right, that these rights aren't going to be given to us. We have to protect them by zealously advocating for our clients. Okay.
Nothing taken for granted.
Correct. So the long and short of how we did that in this case is I immediately evaluated all the evidence. It was like 15 body cams. It wasn't much, but I assumed that, and I'm speculating here, but for 4 months, I don't think his previous lawyer did any of this. Okay.
Huh.
So we approached the judge and got an order signed by the judge in June. So a month after I start representation on him, saying that all the evidence produced, if there's anything produced after this order, it will be excluded from evidence. So I wanted to do that, Jim, because sometimes prosecutors kind of hide their really bad evidence until the end and kind of surprise us with it.
Right, sort of spring it. It's last minute kind of thing.
Yeah, and it's what's beautiful about Texas law, Section 3914, is it says as soon as practicable. And what that means is if we've asked for it and it's there and they haven't produced it yet, well, they're violating as soon as practicable. So the state and the arresting agency better turn over all their evidence pretty damn quick, because we have a right in this country to a speedy trial.
Yes.
Right? Okay. So the judge says, okay, well, all the evidence that we have, that's the only thing that's coming in. Okay, then we have the suppression hearing. I finally am getting to why there was no exigent circumstances, Jim. There was one video of him calling the DA that I alluded to earlier, where the DA said, well, you need to go get the officer to, or you need to be sure that the victim was in fear of imminent bodily harm, right? Well, on the stand at the suppression hearing, I got the officer to admit that it was exigent circumstances. Then I played that video for him, his own video that said, so you just had a 45-minute silent call with the victim, and then now the timestamp on this is an hour later, and you need to reconfirm that the client was in in fear of imminent bodily harm. We just established on cross-examination that pointing a gun at someone makes them in fear of imminent bodily harm, right?
Okay, yes.
So the judge denied our motion to suppress because, I don't know. I don't want to get into the reasons why, but
okay.
But we went to trial on the retaliation the next day, which was unfortunate because the state was acting punitively with my client because he might have said some racial slurs And the district attorney in this case was just so happened to be an African American female. Okay. So they tried the retaliation first. Even though all these charges stem out of the same transaction, the state has the opportunity to elect which case they try. And the point of that, Jim, is that they could only prove the retaliation. So that's the threat made against the officer by my client.
Understood.
Because my investigator contacted the complaining witness, and the complaining witness was like, yeah, I mean, we had that altercation, but I haven't had any problems with his family now, and I don't think he should go to jail for this. And I play that for the DA, and the DA just chooses to disregard it. Once again, this is the home of the brave, right?
I understand. I see where you're going.
Yeah, we're not just the state's not gonna be like, oh, here's a valid reason to let this go. There was so much emotion in this case. So we go to trial on the retaliation, and was the officer in fear of imminent bodily harm from what my client said to him. Very similar to aggravated assault, but these are just words that the officer hears in the course of discharging their duty as a peace officer. Okay.
Understood.
And this officer on direct said, well, one of the threats was when my client, quote unquote, walks out of here in 5 years or so. And then the other was when my client was handcuffed. He said some things that were a little threatening. But it wasn't an imminent threat because my client was arrested. He wasn't able to do anything.
And in handcuffs.
Yeah, that's what I mean. And so the state passes the witness despite their not proving an imminent threat. I asked 3 questions on cross. The jury's excused for lunch, and the judge, in all her wisdom, intervenes in the trial, and we get an immediate offer for dismissal of 2 felonies. So my client doesn't have to wait in jail while we try felony 2 and felony 3, right?
Yeah.
And the retaliation is reduced to a misdemeanor terroristic threat. My client kisses me, hugs me, but there was 3 months of trying times in there, but it all ended in a happy ending. So,
and I know you were excited about that because I talked to you right after that. So there was emotional involvement on your part as well.
Yeah, I remember being pretty emotional and very happy for my client at the time, Jim. And I'm glad you listened to me talk all about this then and now. So
let's take this to a potential client. And how can they avoid a scenario like this happening to them? Just know their lawyer better?
I mean, we can't control what's going to happen.
I understand.
Right?
I understand.
At the end of the day, it took me a long time to figure out that the police officers, they're my job provider. So at the end of the day, I shook this officer's hand, even though despite I disagreed with a lot of the things he did. But, a lot of my clients, Jim, deal with their problems by not dealing with them. And I think there was a podcast that we did earlier about the attorney-client privilege and how that's
yes,
that the appointed clients don't trust their lawyer. And so these podcasts, Jim, are a good way for potential new clients to meet me before meeting me. And I am very grateful for this opportunity to do it with you. And so I think all I can really do is just give, by way of example, things that we do in order to make sure that the client and his family are all on the same page. We're all communicating. They're all understanding our strategy to get what I want is a walking referral, right?
Yes.
And what they want is their very results. And so in this case that happened, we were lucky enough to get that. And so I would just like the public to know that the 2 biggest fears I have as a criminal defense lawyer are, number 1, an actually innocent client. I mean, my client in this case was innocent for the most part of everything he did, but he did react in a very poor way rightfully so. It was sort of a justified resentment against the police intrusion, but they still did the intrusion, Jim.
Yes.
So we've got to kind of, I use this a lot with my clients, that when they find themselves in a hole, to drop the shovels. but see, that requires them to take personal responsibility for the hole that they're in, which is in and of itself a very bridge too far sometimes.
So basically, when you've dug yourself into a hole, put the shovel down.
Yeah. And the second fear, and that's what totally relates to this case, is that we need a lawyer. The second biggest fear we have as criminal defense lawyers is a cop that tells the truth. And in this case, it was a lot easier than in other cases to find out where this police officer wasn't telling the truth. So, and then roll up our sleeves and go to bat for our clients. And all the while, it's fun. That you asked the question earlier, Jim. What would I want to say to a client to avoid this? Well, I mean, if you're avoiding it, you're not meeting us. But in the event you do not avoid it, I think these podcasts and these conversations with you, my good friend Jim,
Thank you.
are paramount to people getting to know their lawyer first, right? Because I can't expect you to trust me until I tell you a little something about myself.
Understood. Wow. What another interesting conversation. Hunter Simmons talking more about home of the brave and what it takes to maintain that. Thank you for your passion and everything else. This has been Jim Bratton, and we've been talking to Hunter Simmons. Thanks for listening.
Thank you, Jim.
This has been Jim Bratton Podcast, Business Edition. Contemporary business conversations. A Jim Bratton production. I'm Sierra Safel.